Yeah, Mr. Speaker and members, I would rise to make a point of order at this point. This motion involves a bill that was killed by the Judiciary Committee, and I believe at this point, and we've had a few other votes where there's been an effort to bring back a bill that has been killed in committee. I would ask a ruling from the chair as to Mr. Speaker.
Thank you, Senator Rashford. On your point of order. Do you have anything to add?
No, just I'd like a ruling on where we are in the process. This is a bill that was killed, substantially similar to a bill that was killed in committee, and just a ruling from the chair on what would be required for the body to take this up.
Thank you, Senator Rashford. Senator Erdman, I give you the opportunity to respond to Senator Rashford's point of order.
And Mr. President and members of the legislature, Senator Ashford is correct. LB 102 was heard before the Judiciary Committee. This is not the exact same language. However, it does accomplish a substantially similar result. I would offer the idea to the body that the motion to return is in order, as it is provided in our rules. However, the motion to adopt the amendment would require 30 votes, and I would believe that would be consistent with the ruling of with the interpretation of our rules that this motion is in order, given the fact that our process would require the body to cast 30 votes in favor of the motion once it's been returned to select file for its adoption.
The chair rules that the motion to return to select shall require 25 votes. The chair rules that a motion to adopt Senator Erdman's amendment does and is pursuant to Rule 6 sub H of the legislature's rules and therefore shall require 30 votes. Senator Erdman, you are recognized to open on your motion to return LB 185E to select.
Mr. President and members of the legislature, it's not with great excitement or over the objection of the committee that I rise lightly to offer this amendment. LB 102 was brought to me at the request of the Department of Health and Human Services. It generally does coincide with the language found in LB 185, which was a technical bill that was brought to the Health Committee by the Department, dealing in one part, sections 1 through 3, 10, and 13, with the Medical Assistance Act, and it updates the references in federal law, as well as making technical changes to the Medicaid estate recovery and spousal impoverishment provisions. The amendment before you is germane to LB 185. In fact, it's within the same section of law. It did go to the Judiciary Committee. Unfortunately, I was unable to attend the hearing due to previous commitment, and the bill was presented both by my staff and the Department was present. I'd like to share with the body some information. Ultimately, I would not have done this without the insight or acceptance, at least, of this accommodation by Senator Johnson, and recognize fully that if this is problematic to the body, that it can be withdrawn. However, I believe that there be some additional information that may be an assistance to the body, and ultimately recognize the limitations that I am under, as well as the obligation of taking the body's time in this discussion. The state Medicaid programs are administered within broad federal guidelines and are financed jointly by the states and the federal government. Most of us know that already, and if you don't, you'll soon figure that out throughout our discussions this session. Federal law has required the Medicaid estate recovery since 1993. The amendment before you does not create this authority in statute. The amendment before you is simply the process in which the state would pursue the recovery effort. The state must, at a minimum, seek recovery for services provided to a person of any age in a medical institution or are 55 or older that have received certain services. You have received a handout that outlines the technical issues with the amendment, as well as the limitations on the Department of Health and Human Services on the type of recovery that they can actually successfully accomplish. In September of 2005, the United States Department of Health and Human Services released a state-by-state analysis of collections from 2002 to 2004. Nebraska had a collection rate of 0.03% of nursing home spending. Nationally, that rate is 0.08%, and South Dakota, which is a similar notice as the one proposed in AM 405, has a recovery rate of 1%. Nebraska currently has provisions where the state may waive its claim based on undue hardships. These guidelines are prepared in conformity with the standards specified by the Secretary of Health and Human Services for such a waiver. That's a federal secretary. Nebraska also provides for a further exemption of property of $5,000 for adult children to ensure that limited assets will be available to be passed on to other family members. This bill does not affect the priority of other creditors, and it is based on increasing the efficiency of estate recovery as mandated by federal law. The back half of the handout that I have given you is a bullet point of the process that's currently in place. Effectively, here's how the law works in Nebraska. And the amendment that's before you was worked on with the Nebraska State Bar Association. It is consistent. It references the statutes dealing with other creditors. Here's how it works. In the state of Nebraska, notice is given when an estate is commenced or the proceedings have begun. We have folks at the Department of Health and Human Services that simply read the obituary notices and those public notices in the newspapers to figure out how we can comply with this federal requirement of the Medicaid Act. Amendment 405 would simply add that when the other creditors who are subject to the opportunity or who have the opportunity to file a claim on the estate get that notice, that the department would also receive that same notice. They do not receive any expansion of authority in order to recover. They are still held to the same standards that are in existing law. Again, this allows them to receive the notice that every other creditor would receive. The existing law is in 42 U.S.C. Section 1396, which mandates the Medicaid estate recovery. Some of the undue hardships criteria are if it's not in the best interest of the state. What would that mean? In the event that we go out and try to claim assets from an estate, which would impoverish the recipients or the heirs, it is not in the best interest of the state. Example specifically would be if the heir of the recipient resides in the recipient's home and provided unreimbursed care, or in the event that we would accomplish the recovery, that the heir would become eligible for public assistance. As I understand the testimony at the hearing, some of the questions were, could somebody go out and claim, or could the department go and claim somebody's wedding rings and those types of assets? If you read further on, there is exempt property. Adult children, 21 and older, are entitled to $5,000 worth of property or assets. So in addition to the restrictions currently in law, there are additional restrictions in law as to actual assets above what we're limited to receive under the federal guidelines issued to us by the Secretary of State in compliance with federal law. With that, Mr. President, I know there are lights on. I would imagine there are members of the Judiciary Committee who are probably opposed to this as they were the bill. I felt it was appropriate, as it opened up the same section in LB 185, to have the discussion. Obviously, if it's the will of the body not to proceed, we will address that. But if we're talking about utilization of state resources in an effective manner, hiring people to figure out how to comply with a federal requirement and requiring them to read every newspaper that may have these public notices in them, to me doesn't make a lot of sense. And if there's a better way to accomplish it, we can work through that. Again, this is consistent with how every other creditor would receive notice. We believe, and I believe in visiting with the department and have come to agreement with the concept and with the State Bar Association, that this is not onerous. It's simply an opportunity to alleviate the fact that we have folks who sit at an agency, and in order to comply with the requirement that we have placed on them, they have to go and find the information through public notices in weekly or statewide newspapers. Thank you, Mr. President.
Thank you, Senator Erdman. Chair recognizes Senator Ashford, followed by Senator Chambers and Lathrop.
There are other lights on this issue. This bill was killed in committee, basically not because Senator Erdman wasn't there, and of course would have loved to have him there, but essentially what this does is it creates an added obligation to send a notice directly to the Department of Health and Human Services. It is an obligation which is greater than the way notices are sent to creditors, to other creditors. So it is an added obligation that would be put upon a personal representative or essentially a personal representative after a decedent passes away if they're over 55 years old. There just was no rationale or reason concern about cost or notice or whatever. I think it has to be dealt with comprehensively and not piecemeal as it was here, in all respect to Senator Erdman bringing the bill. Certainly we do not, I think the thinking in the Judiciary Committee was that this added obligation is just simply not justified by the facts of why the Department of Health and Human Services should be held, given this extra benefit was just felt to be not appropriate, and we killed the bill.
Mr. President, members of the legislature, this is not the same language that was before the Judiciary Committee. That's why the rule says substantially similar. It is substantially similar in that it opens the same section of law, it applies to the same topic, but it is not the same method. The method has been changed. Senator Ashford pointed out that one of the concerns that the committee had was the time frame and the notice and the additional responsibility placed on a personal representative. In Senator Lathrop's example, if you are a personal representative for somebody in the state of Nebraska now and filing their estate, and you know that that individual was a Medicaid recipient that fits this definition, you currently have this obligation under law. The question is, if you didn't know, and we have this requirement, isn't it simpler for everyone to allow that representative to use the same notice to go to the same folks that are creditors now and add the department to that list and let the department determine that? In the event that you're a personal representative today, you know that the individual is under Medicaid, is going to be subject to the estate recovery provisions, and you do not notify the department, you have that liability now. And the department can challenge the estate collection altogether. So this is not new authority. What this is adding the department to the list of people who are going to get the same exact piece of paper from the personal representative. I understand that there are some concerns, and the opportunity to work with the committee would have been the desired way to do that. It's my understanding the bill was killed the same day it was heard. As I was not here, and my staff did not have the opportunity to visit with the committee about their concerns, or myself, after the actual hearing was ended, there are limited options or remedies available to me as a member. Ultimately, if the body doesn't think that this is a good idea, we can stop it pretty quickly. You can vote not to return, we can move on. But recognizing the fact that we have worked directly with the State Bar Association and how they treat all other notices for creditors, and we're using that existing law to accomplish the same goal, and recognizing that personal representatives have this responsibility if they know that the individual is under a Medicaid estate recovery provision now, this simply allows us efficiencies in ensuring that we are doing our best to comply with the federal law under the Medicaid Medical Assistance Act. This bill could have been included, this provision could have been included in LB 185 when it went to committee. And so to respond to Senator Ashford's comment about being a holistic approach, he is correct. And in fact, I made that recommendation to the Department of Health and Human Services when they introduced LB 185. I said, you should have just put that bill in this one. It's a technical bill in nature. The responsibility is there. It's not a new obligation for those who know it's there. It simply allows the department the opportunity to receive the notice directly when that is filed. They said we were concerned that there may be questions about what we were attempting to accomplish. We didn't want to make it a holistic approach. So I wanted to provide the body with that additional information. I am not standing on this floor saying that the Judiciary Committee is wrong. Not at all. In fact, I have heard their concerns, and I believe we are trying to address them in a fair way, both for the estate, those who are heirs, as well as for the department, who have a responsibility to recover under the estate per federal law. So it isn't the same language. We did listen to the committee. We didn't thumb our nose at the committee and go, well, you know what, you're right. And we didn't ignore the State Bar's request. That's why there was 2 amendments filed prior to give public notice of some different ideas that we thought would accomplish a goal and to get feedback. Ultimately, in working with the State Bar and gathering that feedback, we arrived at AM 405. So again, AM 405 does not give any additional authority. What it does is it adds the list of recipients of the creditor notice to the Department of Health and Human Services. It takes out any date timelines and makes the law consistent, again, with the provision of law in 25.520.01 that deals with the published notice. I hope I understand that correctly. I visited with Senator Ashford. I think that's accurate. It's substantially different than other scenarios where we've tried to pull a bill out of committee in the green copy. This is not the green copy. Senator Chambers is right. We have tried to make it better. It may not stinketh as bad as it once did, and it still may not be a pleasant odor to your nose, but it's better. And whether or not you agree with this policy or not, I think it's inappropriate to ask employees of the state of Nebraska to sit and read public notices through newspapers and other means to determine whether or not we can follow federal law. Again, this simply adds the department to the list of creditors. It addresses a lot of the concerns that we heard from the committee, both directly and indirectly. And again, it has been agreed to by the State Bar. Thank you, Mr. President.
Hopefully we can bring this to a vote soon, very soon. I do not support bringing this back, and the reason for it is there's many reasons for it. The most important one is, as Senator Chambers suggested, is precedential. It is a change now. The amendment that I have before me is somewhat different than the bill that was introduced in the Judiciary Committee, in that it does not change the time frame when the notice must be sent. The way the bill was originally introduced, it was required that the personal representative send notice within 14 days to HHS if the person is 55 years or older when they died, and if they're in a medical institution at the time. That was why we killed the bill. We felt that it was an onerous provision and was not necessary because there was a 30-day provision in statute as it sits now. This is a confusing area of the law. This should be handled in the Judiciary Committee. It should not be handled on the floor. Quite frankly, my reading of the amendment, and I was going back and forth because this is a change or a different amendment, is that they're simply restating in the amendment what already is the law, that a creditor, HHS would be a creditor, HHS should receive notice of the claim within 30 days as any other creditor would do. Yes, HHS must, to ensure that they are able to have information about all the individuals that would be potentially a claim would be filed for in their estate. They may have to read the daily record. That may be the case. But this is a complicated area of the law. It is a change from the bill that was introduced to us. And as we get further down the line, if the standard is going to be, it's not, and this is in all due respect to my friend Senator Erdman, if we're going to change it slightly so that it isn't really the bill that was acted upon by the committee, but it's different, and therefore it ought to be considered by the full body. This is not a huge issue to the state, but there are going to be massive issues that we're going to be dealing with in the next several weeks where that argument could be made. We simply must not advance this kind of an amendment, not because it's not meritorious, not because Senator Erdman is doing this in any other way other than trying to do something that he feels is right, but as we get to more significant issues, it could become very, very difficult, especially in the last couple weeks of the session, when a bill is acted upon on committee and a member may feel that that's not that it should be on the floor. If we could take this up again next year if HHS wants to introduce a bill again similar to this amendment. The Judiciary Committee will consider it. If it's something that ought to be changed, and if there's a reason to change it, we can most definitely, we'd be more than willing to take another look at it next year. This doesn't need to happen today. It creates in my view, a precedent that we may not be happy that we've set. So I would recommend that we not adopt this amendment, that we do not return the bill to select file, that we move ahead with final reading on LB 185, and I will be more than happy to work with Senator Erdman and HHS and the bar, none of whom I've talked to in the last several weeks on this, so that we can get a bill out next year that will meet the needs of HHS if appropriate. Thank you, Mr. Speaker.
Thank you, Senator Ashford. On the Chair's own motion, it is the ruling of the Chair and the intent of the Chair to amend my original ruling with regard to the number of votes required to return a bill to select file from final reading. Pursuant to the rules of the legislature, Rule 6, Section 6, in that first paragraph, a motion to return a bill and select shall require a 3/5 vote of the elected members. Therefore, to return LB 185E to select, 30 votes shall be required. You're recognized to close on AM 405.
Mr. President and members of the legislature, I appreciate the insight of those that were on the committee, specifically Senator Ashford, Senator Chambers, and Senator Lathrop. I appreciate your indulgence this morning. I'm somewhat at a loss as to the arguments against this motion. Not from the senior member, which I think his point is well taken, that we should preserve our committee process. And I wholeheartedly concur with him and have in fact voted against the advancement of bills that I thought were in an inappropriate form that are now on the floor of the legislature. And am now trying to do my work to fix those now that they're here. And I won't give you how that vote came out because I think it's kind of ironic. Why was the bill killed in committee? Well, I've been told that it was onerous to the personal representatives. It was 14 days. That was a different timeline than other creditors. They killed the bill. Fair enough. I took that under advisement. We came back with a draft that said 30 days. The folks that are subject to this law and follow this area of law said, you know what, that's even a little onerous. Let's just follow the other process that's already in place on creditors and use that as a standard. That was agreed to by the State Bar Association. Generally, the folks who represent those that become personal representatives. They agreed to it. We filed the amendment 2 weeks ago. I informed Senator Ashford prior to that I was going to attempt to resurrect LB 102 in a different form based on the concerns that I had heard. So what I heard today was that this is 102, kill it because it didn't address the committee's concerns. When it was revealed that it did address the committee's concern, I was told, kill it because it set some precedent. What's the precedent? That we listened to the committee, that I wasn't given the opportunity to work with the committee to have it in a form that would be advanced, and therefore I had no other options if I felt this needed to be addressed. So I am sensitive to the committee's wishes, and in fact, this amendment wouldn't be written this way if it wasn't for the committee's concerns. There's no precedent being set here. I've been here for 7 years. This happens before. Whether it's right or not, it's happened. That's what a precedent is. When something happens, that then begins a process. Our rules are about that. They're written generally, but when a precedent happens, it potentially can offset those rules. We've had that happen. In taking some of the wind out of Senator Chambers' sails, my motion will receive no votes this morning. Mr. President, I would ask that the motion be withdrawn and that we proceed to vote on final reading on LB 185E. Thank you, Mr. President.
Thank you, Senator Erdman. Your motion to return to select file for a specific amendment is withdrawn.
The basic idea behind LB 402 is to streamline the redistricting process and put it into the hands of this nonpartisan entity, as it is done in Iowa. And the bill authorizes Legislative Research Division, which makes eminent good sense, in my opinion, because they have been involved in the process at least since 1991 to some extent. In the bill, the division would only serve as staff and present ideas, essentially maps drawn on up-to-date information from the U.S. Department of Commerce. They would present it to the Redistricting Committee, which is the actual committee that would administer the Redistricting Act. The Redistricting Committee itself would be appointed by the Executive Board and composed of 9 members. And this is exactly as it was done in 2001. There would be 3 from each congressional district, with no more than 5 from the same political party. The Redistricting Committee would introduce shell bills at the beginning of the session, just like any other bill, and then specific plans that are developed by legislative research would be amendments to districting bills.
Thank you, Senator Shimmick. Mr. Clerk, motion on the desk.
Mr. President, Senator Erdman would move to recommit LB 402 back to the Executive Board.
Thank you, Mr. Clerk. Senator Erdman, you are recognized to open on your motion to recommit to Executive Board.
Mr. President and members of the legislature, I hope you vote for this motion. Because if you don't, then we have to do what should have been done in the committee. There are a number of problems with LB 402. Senator Shimmick is aware of some of my concerns, and I'm sure she's had an opportunity to view the amendment that I have offered. This bill was heard on the same day as another bill that was advanced from the committee without the opportunity to amend, and now we're going to do it on the floor. So whether we agree with the philosophy or not of what Senator Shimmick is trying to accomplish, if we are going to do this, there are some major issues that need to be addressed, and I see that we have two options. We can try to send this back to committee and allow the committee to work out a committee amendment, bring that amendment back to the full body and discuss it, or we can proceed to an amendment that I have filed. I see Senator Shimmick has an amendment filed on select file. I also have a motion to indefinitely postpone LB 402 filed as well. I hope you have had the opportunity to read the bill. And let me preface any of my comments by saying this. I have absolute respect for Senator Shimmick and what I believe she is trying to accomplish. We have a fundamental disagreement on how. LB 402 and why I think it should go back to committee to be fixed. In Section 3 of the bill, the Committee of Redistricting, which would become a committee that's similar to what Senator Shimmick has proposed on her Special Committee on State-Tribal Relations, would have to be put into our rules as well in order to allow them to be as effective as they should be as any other standing committee. Ironically, that's how we did it, or excuse me, as a special committee. Ironically, that's how we did it in 2001. We may have had enabling legislation to get the information, but ultimately the redistricting committee was in rules, not in statute. And I think that's a widely accepted reality. But the committee shall be appointed by the Executive Board in January of each year ending in 0. So let's go back to 2000. 2000 is the last year of a session. Somebody may be term limited out in 2010. The Executive Board will appoint the committee in 2010. Whoever those members are will be compelled or shall continue to exist through the redistricting process and shall be reconstituted in the event of a successful legal challenge. That's the committee. Senator Friend is going to be here in 2010. It's my understanding Senator Friend's not going to be here in 2011. Senator Friend has every opportunity, and I would believe obligation, to attempt to be put on the redistricting committee in 2010, according to this bill. In the event that Senator Friend is put on that committee, as I read the language, he will no longer be a member in 2011 when we actually have to vote on it. My timeline says you make the appointments in the year ending in 1. You can avoid that. Again, I hope you've had a chance to read this bill, and it's not contrary to what I think Senator Shimmick wishes to accomplish. If we're going to have a committee, let's use it. And if the committee doesn't want their responsibility, of which I'm a member, then let's not accept these bills to be referenced to us. I think that would be fair to Senator Shimmick, and I think that would be fair to the body. Senator Chambers pointed out earlier that you don't have to have a lot of skill or talent or expertise to be a chair of a committee. Guilty as charged. But at least we have the time, and before we'll advance a bill out here, my committee members are willing to allow us the opportunity to work with the members to resolve the issues. That was not afforded on LB 402 to Senator Shimmick or to the members of the committee that had concerns. And you'll notice the chair of the Executive Board voted no.
1 minute.
The Speaker voted no. And little old Senator Erdman voted no. But it takes 5 to advance. 5 votes were there. Actually, 6 were. So this is not at this point about a disagreement about whether we need a bill or not. This is about if we're going to do a bill, it should be drafted. It should be done out of respect to Senator Shimmick, out of the members of the committee that were tasked with the responsibility of reviewing the legislation, and to be the gatekeeper from bills coming out here in poor form. If we're not going to do that, then why on earth do we reference bills to committee? I think it's fair at this point to ask the body to recommit this bill to the Executive Board. The committee hearings are completed for most committees. We would have time in the afternoons to be able to have this discussion. if the members of the Exec Board would attend.
Time.
Thank you, Mr. President.
Mr. Clerk, items for the record, please.
Mr. President, at this point, I just have an announcement. The Banking Committee would like to have an executive session right now underneath the south balcony. Thank you, Mr. President.
Thank you, Mr. Clerk. You have heard the introduction, members of the legislature, on the recommit motion to committee. The floor is open for discussion. Senator Erdman, your light is next.
Mr. President, out of respect to Senator Shimmick, if she would like the opportunity, I would yield my time so that she has the first opportunity to respond to the motion that is before us. Senator Shimmick, I would yield you my time.
Senator Erdman mentioned a desire to avoid chaos in this process. I've never witnessed a redistricting effort that didn't involve chaos, because you're dealing with political careers, you're dealing with incumbents who want to protect their districts and their ability to be reelected. So my experience observing this over some 32 years is that every time you have redistricting, there's blood on the floor. I'm not sure how I'm going to vote on this resolution to recommit to committee. I can tell you, though, that if certain things could be worked out with this recommitting, I could probably support it. What am I talking about? We know that in a redistricting season, there is the temptation always of incumbents to protect themselves. This is strengthened by the fact that legislators want to draw their own maps and literally choose their own voters. I don't think that's a good idea, but that's the way often these things work out. It seems to me there's an inherent conflict of interest present when legislators design their own political futures. There is precedent in other states for the creation of independent commissions that can reduce the partisan influence and the corrosive effect of incumbent protection. Right now, 17 states currently give independent commissions some role in redistricting decisions. Only 4 of those states, however, give them the final say. You can have an independent commission make responsible recommendations that could be subject to judicial review, and this could perhaps improve the process. So, back to my original point. If this resolution to recommit to committee would allow us to take it back to committee and consider the positive benefits of an independent commission that would create a process based on objective criteria and fairness, one that would inspire confidence in the process, then I can support this. I suppose then that would require me to ask of Senator Erdman a question and would request that he yield.
I'm sorry, Senator Avery. Senator Erdman, will you yield?
I would, Mr. President.
My question is, if we vote to recommit to committee, would that committee be able to consider the broad range of alternatives in how we structure the redistricting, including the creation of an independent, nonpartisan commission to make recommendations?
Senator Avery, I have no opinion of how the committee would conduct their business. It would be my opinion that if the bill is recommitted, that if you had that idea, you could submit that to the committee for our discussions as well. I don't know that it would be supported, but you could definitely submit that, and we could consider that along with all the other concerns that I have.
Thank you very much. I suspect that when you start talking about trying to remove partisanship from something so partisan as redistricting, it might be considered pie-in-the-sky thinking. I'm usually not guilty of pie-in-the-sky thinking, but certainly I believe that this process throughout the United States. And by the way, we're the only country in the world that does this, and I think that is a great compliment to us, because it's a very difficult thing to actually go about the painful process of redistricting our representative bodies in order to stay true to that one person, one vote principle that we adhere to and we try to promote around the world. But we're the only democracy in the world that does it. So I think this is worthy of consideration, and to the extent that I might be able to influence that committee to consider this, I think I will vote to recommit. Thank you.
Thank you, Senator Avery. Before we continue, Senator Wallman would like to announce that there are 35 students, fourth grade students from Cedar Elementary in Beatrice, Nebraska. They're located in the north balcony. If you would rise and allow us to welcome you, please.
Is this a silver bullet to move it back to committee? I don't think so. But I guarantee I don't like the shotgun approach that we're using. Let me go through the bill, because it may be of value for you to understand all the other issues that are addressed in this bill that need to be corrected. And since I can do it in probably 5 minutes, then we can at least have an understanding, and then you can decide whether or not you want to fix it on the floor, or if it needs to be fixed, or if the bill even needs to be here. If you go through the bill, the green copy of the bill, you go down to Section 3. I've already talked a little bit about the timeline. You can appoint a member whose term limited out in 2010. They would be further a part of that committee, and obviously we'd have to have a provision in here, or you would preclude those people with that senior experience from being a part of this process at all, because they wouldn't be here the year we actually voted. And you had the public hearings, and you went out to the congressional districts, and you did the video conferencing, and you had the debate on the floor. So it technically would probably be more of an independent commission that Senator Avery is looking for than he thinks, because of the fact that you'd have people who are no longer members of the legislature, which I believe would probably either be unconstitutional, and if it's not, it would just be a really bad idea. A vacancy that's filled by the executive board, a vacancy on the committee shall be filled by the executive board within 15 days after the vacancy occurs. That's on page 3, lines 6 through 8. This is going to be done in a legislative session with 90 days. Now, that sounds like a lot of time, but as all of you are aware, we're almost halfway through this session as far as legislative days. Most of this work has to be done early on, as it was in 2001, as it has been done this year with other bills, to make sure that those bills are ready for floor debate when we go to full-day debate. 15 days is too long. It should be as soon as it's practical. It should be upon whatever the term needs to be, essentially immediately, so that in the event that we have a vacancy, for whatever reason, that vacancy is filled as soon as is practical to make sure that this process continues on. Further, if you go to page 3 in section 4, subsection 3, line 22, if in preparation of redistricting plans the director is confronted with the necessity to make any decision, now this is the director's authority, to make any decision for which no clearly applicable guideline is provided by Section 6, which are the guidelines that Senator Shimmick has pointed out that we have generally adopted by legislative resolution in this body when we did redistricting in 2001, the director may, and that word is circled. It was circled by the senior member of this body. It was circled by a bunch of other of us on the committee and said that is not the right language. May, resolution in this body when we did redistricting in 2001, the director may, and that word is circled. It was circled by the senior member of this body. It was circled by a bunch of other of us on the committee and said that is not the right language. May submit a written request for direction to the committee. In the event that we don't have guidelines that are specific enough and address every issue, the director of research for the legislative body, an employee of ours, gets to make that decision on their own. That word at least needs to be shall. If they are going to be at the direction of the legislature, if they are going to be the staff for the redistricting committee, they should act as other staff for committees do at the direction of the committee. Further, you go to page 4, section 5. The committee shall introduce redistricting plans as amendments to redistricting bills. Unnecessary. That's how every other bill gets addressed, and in fact, that's exactly what we did in 2001.
1 minute.
Shell bills were introduced. Once the committee determined what the plan was, they had public hearings on it. Once the public hearings were held, they had the amendments filed, read by the clerk, and debated on the floor. Section 6, again is unnecessary in my opinion, as it can be done, and it can be actually more specific. Some of the testimony in front of the committee that day was concerned that it doesn't preserve some of the issues that have generally presided over redistricting in the past and have resulted in the division of areas such as Sarpy County into 3 districts when other counties in the state have 1 representative. And I'll continue on with my light at the next opportunity. Thank you, Mr. President.
I'm one of the new senators. I think that, as is Senator Avery, and it appears to me, in my recollection, that maybe this is the first time that Senator Avery and I are in agreement on something. It does sound to me as though this needs to be recommitted to the committee. We can take a lot of time talking about these individual amendments, but there's enough here in this bill that we've heard discussed that I think it would save time in the long run to send it back to the executive committee if they have time to address these, and apparently they do, and at least iron out some of the things in the interest of time before it comes back to us again.
Senator Nelson, thank you for your kindness. Where we left off, at least on my time, we were discussing a little bit about Section 6, and Senator Shimmick and I have followed up on it. If you look at the committee statement, there was an individual who represented himself, came down to the legislature simply because of some of the concerns that they have seen in their area. I believe he's from Sarpy County. Came down and had some concerns about the broadness of the language, and even though Senator Shimmick says that in other areas of the bill it is more narrowly drawn, he didn't feel it was even sufficient according to the guidelines that we had in the past. So when we go through this process, again, these are the conversations we would have had in committee, or at least I hope we would have, and if we wouldn't have had them in committee, we would have had them with Senator Shimmick, and I've had conversations directly, some of the concerns that I have, and ultimately we may disagree. But similar to the other bill that we heard today, when a committee takes a final action on a bill without having the opportunity to either hear the alternative options that would be available or to think through the ones that are exactly in front of them, I think it's a disservice to this process on the floor. I don't like to be up here talking about Senator Shimmick's bill this morning without saying, look, if we can do this more appropriately, let's do that. I wasn't afforded that opportunity in the committee, and if you'll ask the members of the executive board who were there, even those who voted in favor, most of them kind of nodded their head and thought, yeah, you're probably right, but we don't have the time, let's just kick it out. How many of you have picked a priority bill yet? Wouldn't it be great if those committees would just kick it out? I've got a couple I'm interested in already. I've got till tomorrow about this time to choose. Both of them are still in committee. Why doesn't the committee just kick them out? Because the committees are doing their job. And it's not a knack or a shot at the executive board. It's a reflection of reality, and Senator Shimmick is right. I said it in my opening on this motion. If we aren't going to devote the time, we shouldn't take the bill. That is an institutional issue. It's not a knock on the board as an entity. It's a reflection of reality. The reason I wasn't here and visiting with Senator Shimmick is the retirement committee was across the hall having an exec session, which I'm a member of as well. Let's go back to the bill. Section 8 of the bill on page 6 specifically gives the director the authority to redraw congressional district boundaries and other district boundaries. In the event that that is not successful, excuse me, let me back up. That will be the basis then for the committee's hearings. Once the committee has the public hearings, whether they're in Scottsbluff, Omaha, or Lincoln, or whether they're held here at the Capitol using video conference as well, the committee can only make technical changes to those plans. Technical changes. That seems logical.
1 minute.
However, it does tie the hands of that committee, and I think unfairly so. And I will ask you to recall the testimony that I gave you earlier about how the process worked in 2001, where what I offered was not a technical amendment, but it was a necessary amendment to reflect communities of interest. That would have been prohibited under this bill. And I would have had to convince 25 of my colleagues who weren't affected by the case I was in to vote against the entire plan just to give me the accommodation of going back and trying to make my case when the clerk and the director are the only people that have the conversation when that bill doesn't advance before the committee. Thank you, Mr. President.
Thank you, Senator Erdman.